My name is Josh Chazen, and I am a staff editor and the incoming Executive Symposium editor for the Journal of Business and Technology Law. Today's second panel will focus on copyright and social media, and staff members will be handing out materials before the panel begins. It is also my distinct pleasure to introduce the moderator for today's second panel, Professor Robert Suggs. Professor Suggs joined the faculty at the University of Maryland Francis King Carey School of Law in 1991, following stints as Associate General Counsel of a Fortune 500 firm and Senior Policy Analyst for a Washington, D.C. think tank. In addition to teaching at Carey Law, Professor Suggs has taught at Arizona State University and the Georgetown University Law Center. A graduate of the University of Michigan, Ann Arbor, and Harvard Law School, Professor Suggs is the author of Minorities and Privatization, Economic Mobility at Risk, as well as articles published in the Hastings Law Journal, the Ohio State Law Journal, and the Harvard Civil Rights, Civil Liberties Law Review. His scholarly writing has focused on a wide range of issues, including anti-takeover statutes, small business development, racial discrimination in business transactions, and the effects of racial status on market transactions. He has also served as chair of the Mayor's Minority Business Enterprise Women's Business Enterprise Advisory Committee, and he currently teaches copyright, contracts, and a copyright seminar. Ladies and gentlemen, please welcome Professor Robert Suggs.
Thank you. My job is to introduce our panelists who actually know something about copyright. Starting second from the left is Patricia Aufderheide. She's a university professor in the School of Communications at American University in Washington. She's the co-author of Reclaiming Fair Use: How to Put Balance Back in Copyright. She heads the Fair Use and Free Speech Research Project at the Center with Professor Peter Jaszi at AU's Washington College of Law. She's been a Fulbright and Guggenheim Fellow and has served as a juror at the Sundance Film Festival. On my immediate left is Cynthia Blake Sanders. She's an intellectual property and entertainment attorney at one of our Baltimore firms, Ober Kaler. She focuses her practice on copyright, trademark, advertising law, advertising, and the arts and media law. Cynthia teaches a course on entertainment and sports law at our law school and lectures frequently. She is an active board member of several arts-related nonprofits. Next to my left is Krista Coons. She's an AU grad and a member of Venable's Technology Transactions and Outsourcing Practice Group. She focuses her practice on the protection and enhancement of intellectual property and technology assets. She's done a lot of work with the Digital Millennium Copyright Act, and I think that's her responsibility today. On the extreme left is James Campbell. He's an independent photographer in Washington, D.C. He founded Instant DC, which began as a mobile photography exhibit in 2010 and has since morphed into a strong presence in the D.C. art scene. He is also on the board of the D.C. chapter of the APA, the American Photographic Artists Association, where he advocates for photographer rights. I don't know whether this is symbolic that all the lawyers are on this side and the non-lawyers are on that side, but I hope we will be able to collaborate.
It's fine.
I may be the only one here who has actually practiced under the 1909 Act, but way back when I did. And then I only returned to copyright after a hiatus of over 20 years. The current Copyright Act, the 1976 Act, was still largely designed for the analog world. Copying a protected work was time and resource intensive. The current act was a product of more than 2 decades of very contentious deliberation when it was enacted in 1976. At the time, photocopying was still new, and it wasn't cheap. I thought it was wondrous, because otherwise you had to go down to the financial printer and have stuff set in type. Cheap photocopying didn't arrive really until, I guess, the 1980s. And when did we have home photocopiers? I only got one probably 10 years ago. The acceptability of computer software for copyright protection was only a dozen years old and still controversial when the '76 Act was enacted. Photography was all about film and chemistry, and for color photography, you had stringent temperature controls required, and the best color images involved chemistry so complicated and precise that the required quality could only be achieved on an industrial scale. Music reproduction was a bit easier because cassette decks and Dolby circuitry had been developed by the late 1960s, but this was still analog technology. Duplication had to occur in real time. To duplicate an hour's music, you had to spend an hour playing the music. And every copy was a degraded version of the one from which it was made. And of course, distribution of physical copies was expensive, slow, and inconvenient. And now we have digitalization and the internet, and that has completely changed. Reproduction is costless, distribution is costless, but we've still got this old statute. We've had one kind of, they tried to renovate the kitchen, the DMCA, and we'll see if that actually works very well. I'm supposed to take a survey now, just to gauge how well we're doing with our own use of social media. How many people here, just raise your hands, use LinkedIn? How many people here use Twitter? How many people here use Pinterest? Facebook? Tumblr? Instagram? Flickr? Hi. Reddit? Okay. How many of you have smartphones? How many of you use smartphones to access your social media accounts? How many times a day do you check your social media accounts? Once daily? More than 5 times daily? More than 10 times daily?
Oh, yeah.
Okay. How many of you have ever uploaded a photo, video, or audio, or music onto a social media website? Oh my God, and we're taping this. Keep your hands raised if the media that you uploaded was a product of your own making. That is, you took the picture, you drew the drawing, and okay. Keep your hand raised if you know what your rights are with regard to that media, with respect to others reproducing, reposting, sharing. Okay. Okay, our first panelist is going to be Cynthia Sanders, and she's going to be talking about privacy concerns and fair use as well.
Okay. Are we going to put up the slides, or? I wasn't sure when that was going to happen. So, I like to tell people that the day I got into law school was the day that the internet became graphical, which I guess now is making me look really old. But seriously, I mean, things went from being a cursor on a screen in green to being, you know, as colorful as that. And I mean, I remember my first law clerk job, I had to use Westlaw. I'm sorry?
Oh, yeah.
Oh. Might hurt somebody. Okay. Okay, great. So, but things have changed a lot since then. But what was meaningful to me, I was working at the Maryland Institute after having graduated from it, is that that was also the year that artists started getting hired in droves. And as I went into law school, I wasn't exactly sure what I was going to practice in the end. I had been director of security at MICA. Didn't really want to do criminal anymore, although we can get back around to that today, maybe. But so all of a sudden, there were artists who needed lawyers and designers who needed lawyers, and then everybody started going on the internet, and then all the trademark issues sort of started to pick up. And so intellectual property became a viable practice area when you weren't a patent lawyer. But now we've gotten to the point where things happen so quickly that trying to stay on top of either what rights are being taken from you by people like, oh, say, Google, or other websites that you visit, social media websites, that you can't stay on top of that, let alone what kind of rights you're using if you're sharing, like, say, for instance, an article that you read this morning on LinkedIn. If you clicked the share button and it's not your copyright, what did you just do? So that's where we are today. I work with a lot of people trying, in these products, the social media products, both developers who are creating them and also people who use them in their businesses, like advertising agencies. And so in talking to them, it's become quite obvious to me that really that people have to rely on, because of the amount of time it takes to clear something. And when you're working in, say, for instance, public relations, and you're a social media person for the public relations firm, you don't have time to go get a license before you post that photo of your client that you didn't take. So what do? You have to either decide that you're going to wait and get the clearance policy, or maybe you have enough money to have a blanket policy from the Copyright Clearance Center. But even that might not cover everything. So you haven't any time, so what do? You have to rely on fair use. That's 106, that's the exclusive rights in copyrighted works, which includes reproduction, preparing derivative works, distributing copies, performing the copies, displaying the copies, and transmitting things online. All of those things happen when you do social media. So if you're not the author or the owner of the copyright, you're potentially in trouble. So different people have different feelings about copyright. So I always tell my clients that you should read the terms and conditions of the website that you're borrowing content from. Now that's tricky when you're on LinkedIn and you got the article from one of your friends and then you're forwarding it. You have to spend all that time figuring out where it came from. So now this is the website terms of use for Victoria's Secret. And here you can say that just like most websites, it says any unauthorized copying, alteration, distribution, etc. is prohibited. So most websites are going to tell you that. Some let you share. And it's always good to look because then you could feel a little bit more comfortable. So I think I'm going to go ahead and just jump into this. This is a recent case that I worked with a client. They're a pro bono client through Maryland Lawyers Through the Arts. I'm the president this year. It's very exciting. They are an art performance group that is taking on the social issue of rape. And in the young adult community, the importance, well, for all of us rather, the importance of getting consent, adequate consent before you engage in sexual activity is their social issue. So during the Victoria's Secret runway show, they saw an opportunity to get sort of mass exposure for their issue. Everybody, particularly art students, are very good at technology. They spoofed the Victoria's Secret website. And in doing that, they made it seem that Victoria's Secret was supporting their campaign to obtain consent for having sex. Whoops. And so here's just two of the tweets where they've been sort of fooled by the spoofing into thinking that Victoria's Secret was the person behind that activity. They got 500,000 followers in about 10 minutes, and then what do you think Victoria's Secret did? They took it down. So, as I said before, what do they do now? Their message is suddenly gone. They've got 500,000 followers on Twitter and no place to send them. That's when I get the phone call. What do we do? What do we do? And I said, well, you know, because you're commenting and you're parodying something, you have probably pretty good fair use. If we talk about that a little bit, we can make sure you shore it up as best as possible. And then, well, what do you do about the DMCA? If you ask them to put it back up, then you risk them suing you. Because if you ask for something to be restored on the DMCA, the other party can say, no, it's fair use, put it back up. And then the complaining party has 10 days to bring a case or to do something about it, or else the work goes back up. Well, nobody wants to go up against Victoria's Secret when there's only 2 of you. And so we couldn't get permission. There was no way they were going to give us that. So we had to get comfortable with fair use. And since we couldn't rely on the DMCA really to support us in our fair use, because we didn't have the money to go to court against them, we found a hosting company that was a little more used to clients like, say, Pirate Bay. And so the website went back up, and we did a little coaching about how to use the fair use as best you could. So there you can see there's part of the Victoria's Secret website, but then you can see sort of a non-traditional Victoria's Secret model on the front page. And so that's what they added to it. And the text about consent they added to it. When you pop through the pink part of the website, which is the part they chose to spoof, you know, there's all kinds of ads for underwear. So they slid in, again, their own model at the top. There's a Victoria's Secret model at the bottom. And then those are the panties that they think should be sold by Victoria's Secret. They actually even snuck some into Victoria's Secret stores. So that's what they did. And so we got them back up, and I think the website's still up today, although they've done as much as they can to sort of minimize their problems. You see that important copyright notice, which it would have been, I would have liked it better if it popped up like that, but if you read that copyright notice, it would explain their mission and what was going on with that. So.
Krista's going to talk to us about the DMCA.
Very exciting compared to Cynthia's Victoria's Secret example.
Well, it's the
but-
backstory.
Yeah.
It's also one of the most complicated and technical areas of an already complicated and technical statute.
True, and I'm going to cover it in 5 minutes, so this is going to be very thorough. Okay, so I am going to sort of step back a little bit and talk about the legal framework that we're looking at when we talk about social media and alleged unauthorized uses of content online. I'm familiar with this area intimately because prior to coming back into private practice in the fall, I worked for almost 3.5 years with the Motion Picture Association out in California, helping the studios craft copyright protection and enforcement policies. Typically, when I say that in a group, especially a group full of students, things get thrown at me. So if you guys give me a little bit of leniency, I'll appreciate that. But I think part of the issue is that there's a tension that Cynthia's already touched on, but basically coming from the fact that, as Professor Suggs mentioned, the Copyright Act and even the DMCA really didn't anticipate the kind of global sharing, mass sharing that we're dealing with now. And so artists, corporate copyright owners, and users like the rest of us alike are all sort of struggling to make sense of how to work within the confines of the Copyright Act and the DMCA. So the first thing, I'm not really going to read these slides because if I try to explain the act, it's going to take way longer than I have. But I will mention that we need to start sort of with the Copyright Act because the claim that will arise from the user sharing of content online is a claim under the Copyright Act, and that confuses people sometimes because the DMCA is always coming into conversation. The DMCA is actually a defense. It's an optional safe harbor. It's a way for online service providers to put in place certain policies that will shield it from liability if a plaintiff were able to state a claim and succeed on that claim in the event they went to court. So that's actually a really sort of distant, attenuated effect that the DMCA should have, right? It's like online service providers may have an option to comply or not comply, but if the steps toward compliance are fairly small, most are going to take those steps anyway in order to get the liability, and I think that's where sometimes we get shortcut a little bit, and some of the important fair use components that Cynthia's already touched on don't really get considered. But for the most part, in social media, what we're talking about is a component of the DMCA at 512C. It provides protection for storage at the direction of a user. So whether you're writing a tweet or whether you're uploading a document to Dropbox or Mega Video or a torrent to Pirate Bay, regardless of what it is, all of those things likely qualify as storage at the direction of a user. There are a bunch of prerequisites that an online service provider has to satisfy in order to get protection, but really they're not that great. Most of them are ministerial. Register a DMCA agent, have a policy that says you'll take down, expeditiously take down, that sort of thing. There are two more substantive aspects, the knowledge component of the DMCA and also factors that closely mirror the vicarious liability test under common law. The knowledge factor in particular has been in the media a lot lately because there have been 3 major cases decided within the last year at the appellate court level dealing expressly with the concept of red flag knowledge because the DMCA disqualifies you from protection if you have actual knowledge or an awareness of facts and circumstances from which infringement is apparent. That second prong has been taken to mean, has been described as red flag knowledge, and it's not been entirely clear what that means. I think a lot of corporate, major rights holders, including the studios, have long advocated for it to mean something about like a general awareness. Like if you're the operator of Pirate Bay, even if you don't go on your system ever, you probably know there's infringement happening because you're largely referred to as the #1 source of infringing content in the world throughout all media. So rights holders have long said maybe that should qualify, right? I mean, how can that guy reasonably say that he doesn't know? But courts, Ninth Circuit and Second Circuit, have agreed that there's no such thing as that under the DMCA. The type of knowledge that the DMCA refers to is always going to be a specific infringement knowledge. So it's got to be knowledge of a specific infringement, meaning basically a URL. We can talk a little bit more about what the courts have said there, but for now, I mean, the important 2 components on red flag knowledge, I think, are that there is such a thing as willful blindness that will take you out of protection. So it does exist. You can't be willfully blind, but the knowledge can't be general. So it's got to be knowledge of specific infringement. Also, the Ninth Circuit made clear, and the Second Circuit has agreed, although less clearly, that the knowledge can't come from the rights holder. Because as I'm going to get to in a second, the rights holder has a path for proceeding under the DMCA. So specific URL knowledge has to come from some other source. The Ninth Circuit even gave sort of an example, and I think it was the VO case, UMG VO. They said like a random person, like a third party, a guy from the street, can send in an email saying I saw this infringing content on I saw this content on your site. I don't think you own it. I think it's owned by Sony Pictures. And that can give rise to red flag knowledge. But if Sony Pictures, who knows that they own the content, sends that same email, it won't give rise because they haven't complied with the DMCA. So here's where we get to sort of the nuts and bolts. What does the DMCA really mean? I mean, it basically puts out a procedure that looks like this, and Cynthia already touched on it. But as long as a rights holder starts by sending a compliant notice to an online service provider, the online service provider immediately takes the content down and contacts the user and says, we've got this notice. The user can choose at that time either to do nothing and the content stays down, or to file a counter notification and the content goes back up. But if the content goes back up, like Cynthia said, the rights holder basically has to make a call at that point. It's kind of like pushing the rights holders to make a decision, like, are you going to sue or not? And if you're not in a position to defend against a lawsuit, I guarantee you're not going to feel motivated to put that content back up, no matter how comfortable you are with your argument that it might be a fair use or whatever other, whatever other justification you think exists. So part of the issue with a process like this one is that it becomes almost de facto. People who are posting, users like us who are posting things online, we're very rarely going to take the risk. So what happens here is you very rarely end up actually analyzing the situations presented. You don't usually get into a deep discussion with counsel for Victoria's Secret about why this is a fair use and why it's important and why they shouldn't be taking it down, because this structure already exists and it's so easy for the online service providers to follow, doesn't really beg sort of deeper consideration. But at this point in time, I mean, every major social networking site has this policy in place. You can see it on, Facebook, Twitter, LinkedIn, wherever you go. I mean, they're all purporting to follow this, and for the most part, they do. Some go a little bit further, Google has a couple other things that they've put in place, and they've also recently started releasing transparency reports that go to show how many DMCA notices that they've received. This gets used weirdly by both sides. Google says, we don't need to do anything more about FilesTube. I don't know if you guys can read this, but FilesTube is the #1 site up there. They've received 4 million takedown notices, but that's only 5% of the URLs on FilesTube. And Google says, why would we need to do anything more when 95% of that content is allegedly valid? And the rights holders, of course, say, what do you mean? In order to get those links down, I'm going to have to send 80 million takedown notices, and that's assuming that it's a static site. But nonetheless, Google's sort of tracking this to try to allegedly bolster their support for content. One of the effects of this, or where we end up, I think, is asking ourselves, like, do intentions matter? Like, how does the law line up with what people are really looking to do and how people are monetizing on the web? I mean, Pinterest has very vocally sent a number of press releases at this point, basically saying that they think they're protected by fair use, but the most important part of that argument for them is that they're driving content to the source. That doesn't really come into play in the Copyright Act, though. I mean, whether you're driving the content to the source is a factor under the fair use analysis, but it's not a question. I mean, the Copyright Act is a strict liability act, so if you've done it, you've done it, and you can be liable for copyright infringement unless you qualify under the DMCA. So we're sort of left in this quagmire where, we want to reward good intentions, and everybody wants to be playing together safely, but at this point in time, with the structure that we have, we're all sort of constrained in a world that doesn't necessarily mirror reality. And I think I have one more slide, but maybe we'll just skip it for now because I'm out of time.
Thank you. And thank you for getting my slides up.
I'm glad you have 6 strikes on there, because that's your...
I really appreciate the information that we've gotten already from our 2 speakers, which is very interesting. Thank you. Don't go away. This is forward, right?
Yep.
Thank you. And where am I? Oh, I'm pointing it over there. Okay, thank you. So I've been working with a legal scholar, Peter Jassi, for the last 10 years on a project on copyright and creativity. I'm in a school of communication. I specialize in analysis of documentary film. And originally, he and I started working together because we were mutually interested in a problem, which was, if a lot of legal scholars are identifying extended and extensive copyright as a creative problem, why aren't creatives talking about it more? And so we ended up doing a lot of research, which was fascinating, that has now evolved into 10 different projects funded by a variety of foundations with creative communities across the board, and the latest being journalists. What we have seen very clearly is that people's misunderstandings of copyright, people's understandings and misunderstandings of copyright, as well as the genuine confusion that my colleagues here have pointed out, creates an enormous effect of self-censorship, which is largely invisible to the creatives themselves until it's described, when it becomes overwhelmingly urgent to them. What we discovered was, and we first discovered it with the documentarians, was that people were so alarmed by the possibility that they could be at risk for all of their puzzlement around what was legal and what was appropriate under copyright, and particularly under fair use, which is, of course, as you know, the right to use copyrighted material without permission or payment under some circumstances, and it's those last 3 words that drive everybody crazy. What we saw and we documented and we have published about, and we welcome your attention to, is that, that the future of culture can be documented as at risk of being deformed, impaired, profoundly affected by the fact that people are genuinely confused about what they can do. The good news in this project for me has been that there's been great clarification around the window of use that has become increasingly important with extended copyright, which is fair use. Fair use, those four factors which drive everybody crazy are, as we know, massively unhelpful in terms of making any decisions. But we were very lucky that Pierre Laval, who's extremely smart and also has a wife who's an artist and I think really responds to the issues of creatives, wrote a brilliant law review article that became profoundly influential, describing transformativeness as the key element in a fair use analysis. This analysis, which is made clear in our book, which is out there, it has become, if you follow the case law, and believe me, I did not. I depended on legal scholars who did all of the hard work here. If you follow the case law from 1990, you can see incredible consistency in using two characteristics, transformativeness, which is dispositive, and appropriateness. The third thing that happened was what Peter, Yassi, and I did, which was to work with creative communities to develop standards for their particular community of practice of how to interpret fair use. This became important to us also as a result of looking at the case law, when we saw that implicitly or explicitly judges all look to the actual practices of the actual community. The first people to create one were the documentary filmmakers. I have some copies of their code if you want to take a look at it. The effects on creativity were almost immediate. They started appearing within 8 weeks when 3 films went to the Sundance Film Festival, getting festival clearance with their lawyers using this code. We saw the most profound change in industry practice by seeing that every insurer for errors and omissions within a year of this code being issued all began to accept fair use from documentary filmmakers for the first time in 20 years as a routine matter. We have also seen new work being made. Come on. Oh, sorry. Okay, these are some of the results. And I'm happy to post this on SlideShare if anyone cares. These are some of the films that have been made and widely circulated, shown on public television, HBO, IFC. All of them are fully loaded with fair use clips. This film is not yet rated, has 134 fairly used clips from major motion pictures. These are some of the other communities who have developed codes of best practices and had similar results in their creative practice as a result of understanding both what they can do and what they can't do under fair use. Now the social media part. People often say to us, well, okay, what about the fair use that I make or other people are making on social media? And one basic point we have to make is that fair use is medium agnostic. However, of course, there are issues such as terms of service. But what is really important to us is that fair use is now embedded in all kinds of practice. Here are several examples of memes that have been created. Game of Thrones, Star Wars, and SpongeBob. Who, did you see Patrick in the bottom one? Okay. This is an example of poets who created a code of best practices which allowed this book to be published. This is a book about digital poetry and its antecedents. The use of copyrighted material, social media copyrighted material to create is endemic. This is an example of a really important site in Washington, D.C. for journalism, Homicide Watch. The majority of the pictures of people who've been murdered on this site do come from their Facebook pages, and no, they're not cleared. Can you even see that? That's the picture of the plane that landed in the Hudson. This is a picture that went all over the world. It was taken by a non-photographer who was really thrilled to not be paid for his work, believe it or not. I know that's going to break your heart, but he was an amateur. And once again, the meteor that landed in Russia, similarly, taken by people who were thrilled to see their work be published. This, of course, is deeply confusing to journalists who also feel very strongly that photographers, and particularly war photographers, should be paid and should be paid for every use. At the same time, they are widely using material that people want to throw at them. We are, by the way, creating a code of best practices with journalists that should be issued in around 6 weeks. We also see this in other ways as well. I think you showed a Rebellious Pixels quote. This is an example of work of Jonathan McIntosh, who quite brilliantly repurposes and remixes, and as a social critique, popular media. You probably know his work from Buffy v. Edward, which is a confrontation between Buffy the Vampire Killer and Edward from Twilight. Buffy comes out ahead. So we're seeing that the codes of best practices have been profoundly helpful to people in making a basic analysis about, is my use transformative and appropriate? And we have begun to see people applying this in a social media context, and we think that the codes of best practices approach is very smart. This is the description of this 10-year project is in the book that is out there, and if you're interested and you can find $10 before the end of lunch, you could have that book. I welcome your sharing this slideshow. Of course, use fair use if you only want to excerpt part of it. Thank you.
Okay, so as it states, I am a photographer, and I feel like I'm in a support group when I say that nowadays, but that basically means you have an Instagram account, so that could be anybody. Just a few examples I'm going to share of things that I've found trying to navigate the online space for the past 6 or 7 years, dealing with sharing my work, sharing others' works, and some of the discontents that have resulted. So back in 2010, the iPhone suddenly became my camera of choice. The quality of the images became good enough where you could actually print them out, and I did some test prints on my large format printer at my apartment, and the photos were amazing. You could print out 12 by 12s. I even did up to 24 inches by 24 inches. Pretty large format prints that you could hang on the wall, and they're pretty good. So I wanted to find other photographers in the area around Washington, D.C., who kind of shared in my enthusiasm of this new mobile photography thing. So I used social media to do that. I went on Flickr. They have this amazing geo search I'm sure a lot of you are aware of. And I found 10 people who I thought were posting really interesting work on Flickr using their mobile phones. And at this time, this was before Instagram. This was before, this was kind of the end of Flickr's dominance right at this point. And so I got pretty lucky. The first gallery that I went to liked the concept of doing a group show with mobile photography. And it ended up being Fathom Creative. This was the exhibition space the first year. They had these amazing brick walls. That is kind of a bad tinted picture from the lights, but that's how we hung all the works. Each person had 10 photos, 10 artists exhibiting their works. And even from that bad photo, you could see, the photos turned out pretty well. So I knew I was onto something here. This is something that, whoa, hey, how do we showcase more people? How do we get a community involved here? This is really great. Brands can get involved. We can start getting sponsorships, things like that. So the next year, I got lucky again, and we ended up partnering with Photo Week DC. And we helped them run their mobile photo contest, which was a huge success. And some of our previous exhibitors in the 2010 exhibit ended up being judges for the contest, which was kind of neat. This is some examples of all of our adverts. We actually used the iPhone to create the advertisements, which was amazing to me You no longer need to be in Photoshop, you no longer need to be in InDesign, spending countless hours creating these advertisements. Basically, we were able to print out flyers and put them all around the city straight from our iPhones, which I thought was really neat. The photo on the right is one of mine that I took back in 2011. No editing, straight from the iPhone, and it was so clear to me that I was like, well, why do I have this big giant DSLR camera? Why do I have my medium format camera? Why do I have my film? Blah, blah, blah. So everything was going great, all these good luck things that were happening with Instant DC. We were growing popularity, people were posting our content, people were interested in joining, showcasing their work as well, which was all fine and good. So, of course, we had a Twitter account at that point, and so something happened in our Flickr group. This was the strangest thing. This is the first case example that I kind of wanted to share. A photo that I shared, I guess, what was the date up there? February in 2011. It was this, and I'm not showing the image, of course, because she took it down, so I cannot show it. And I cannot say the name of the person because I don't even know her name because she stopped following me and she blocked me on Flickr, etc. Basically, Instant DC tweeted a photo that she put in our Flickr group. And it says very specifically in the Flickr group that there's a disclaimer, hey, we may use your image to promote your work, and it links back to your Flickr account, so you know when you're putting an image in our group that, oh, we may actually promote your work, so be careful. And as I say up on the slide, most people are thrilled to be selected and promoted, and as Cynthia mentioned as well, I mean, most people are happy, especially amateurs, are happy to have their image shown anywhere outside of their personal social networks. So she commented on her photo, oh my God, why am I getting all these views? Why am I, she got about 400 views in one day on this photo, and she had no idea what was going on. And I realized there's this big, it's kind of a technology gap. It's not really a generation gap because this thing's happening so fast. The understanding of what happens when you post something online, I think that's a huge opportunity to educate people. So I wrote back publicly, because I'm a public person, I talk to people, I say what I think. I wrote back to her, hey, sorry, we retweeted your photo on the Instant DC account, congratulations, you were featured member of the week, She wrote back, please don't ever do that again, like, wow, how could you do this without asking my permission? I said, well, you put it in the group, and there was this big, long public conversation. And I was fine with having it in public because I kind of wanted to show what our organization was about, which was, hey, we're promoting people's works, which is a good thing, which is what I thought. So, so that was pretty shocking to me, but that was pretty much the only incident that happened with Instant DC. So just some quick observations. The majority of people sharing online do not realize the implications of their actions with others' works, let alone thinking about protecting their own. So basically, there's a few other projects I'll go through very quickly that I have to share. This was very shocking to me when I saw this. So everyone that posts a tag Broken Nose on Instagram, this artist that I happen to know personally, he is taking all their photos and repurposing them for this project and using it to generate discussion about what it means for hashtags on Instagram and why are people even sharing these things and kind of the ubiquity and how fluid social media is with photography nowadays. And so he's doing this Broken Noses project and actually just launched this morning. And he's in Spain, but since I found him through social media, we've been friends for the past 3 years, which is kind of interesting. So, this project, some of you might have seen, this was Eric Kessel's. He decided to print out one whole 24-hour period of Flickr photos to kind of point out the obviousness of, look, we're drowning in photography, this is ridiculous, come on. So that was the exhibit. That was the installation. He just dumped all the photos into an exhibit space, which I wish I can get approval to do that in DC. That'd be amazing. I'm sure a lot of you have also seen the Nine Eyes project, and there's been other spin-offs and already remixes of the project itself, which is interesting to me. John Rothman, and he's curating Google Street View. He's probably spending 3 or 4 hours a day looking through Google Street View around the world, random places, finding the most interesting images. And So it kind of points to the future of photography, new photography, social photography. So some of the implications, personally, of what I do with my photos online, I'm kind of a dork. I do a lot of web design stuff. I've been online since 2006, probably, creating websites. I'm on my 12th iteration of websites. I figured out a solution personally that works for me. I disable right-clicking. I even disable touch and save on iPhones. I don't know if some of you have ever saved an image from online. You could just hold your finger on it and save it. I figured out a way to disable that. I, of course, list and link to my copyright page, and I even say on there, hey, ask me for permission to use it, please. And I even have a little donate button. Hey, if you like my work, follow my stuff, you know, buy me a cup of coffee, something, you know. And I also offer a few photos every week for free to download to use as backgrounds, things like that. And I also do state on there that I do email people who violate my copyright, and I email them takedown notices, so they do know that they're going to be put on notice. So, and I'm pretty sure that's it. Yeah, that's it. Thank you.
I think we have two categories of use of social media. We have people that are using it in a very self-conscious, deliberate way, the artists who are who probably have decent fair use claims. And then we have the rest of us who are just posting stuff, who aren't transforming anything. And one of the things I want to address to the panel, or a question I have, is what are the real risks? You know, as long as you just take it down. So you take a photograph, you take a music file, you post it, and if somebody objects, you take it down. What are the practical risks of significant liability, other than maybe a nasty letter?
You run into a person with a registered copyright and maybe a history of enforcement. I had a client run into that with a poem that had been traveling around the internet on chain mails for like 10, 15 years. But they had a copyright registration. She used it in connection with her business, and even though it was like archived, they found it, and that was the only way she could wiggle out of it, was paying money. Now, she's a business, not an individual, but individuals get caught up in it too.
Yeah, it's important to remember that the DMCA doesn't affect at all the relationship between the rights holder and the user. The DMCA only comes into play if the rights holder contacts an intermediary, contacts the online service provider. The rights holder can easily come to you and give you, a cease and desist notice, and they can even still sue you if you desist. And you're not going to be able to claim any assistance from the DMCA. I mean, practically speaking, I think those cases are few and far between. I mean, people with big sticks don't want to go around bashing individual users, so maybe the likelihood of that happening is low, but it certainly is a real risk.
So I think that there is a risk, and it's just what you said, Krista, but the problem is that there's no good way for most people to make an assessment of that risk. They universally, in my experience, have a vastly inflated idea of their actual risk. And so what I'd just like to highlight is that there is a real creative risk here. I'm really completely impressed with what James has been up to, and he's like seizing these opportunities, and he's demonstrating how many creative opportunities there are. And at the same time, there is some ambiguity. So I think that one of the things we have to think about is what is really at risk in terms of cultural innovation and business innovation. And James is clearly on the forefront of business innovation here when people do not clearly understand their risk.
Well, to the extent I have much knowledge about the origins of various artistic genres in the arts, it seems that copyright is a very inhibitive force. Making everything property early on seems to inhibit the kinds of creative collaboration. And one of the areas that copyright protects very poorly, and I think justifiably so, and to our benefit, is say comedy. It's very hard to get much protection of a joke. Now, a comedy routine that's videotaped, oh yeah, that's just a movie. And at least compared to what I remember in the 50s, we're in a wonderland of comedic resources in terms of the variety and the scope and the availability. So is it possible for people that are routinely creative, or maybe for the public at large, to adopt kind of the copyleft sensibility, to stop automatic, because the Copyright Act protects everything as soon as it's fixed. You know, there's no choice involved. So what about people waiving that protection as a default mode, rather than fixing it and getting protection? That's the current default.
I would really love to speak to that, because we have spent the last 10 years trying to figure out what's inside people's heads in these 10 different communities. And we've been fairly agnostic going in about what they experience. 10 years ago, there was a whole group of copyleft people, CC people, the GNU, the open access, the open source people, who were like, we are the vanguard of an open source environment and a copyright light or copyleft environment. And that's the way it's going to go, because this is so exasperating. And I have to say that of the 10 communities we've worked with, we have not found any community or any group of people within any of those communities that is anything more than exceptional, who don't prize their own copyright, at least potentially. So although I think that it might be possible to imagine the growth of a pool of material that is copyleft, actually in the 10 years since we started to work on that, that pool of material has grown exponentially slower than everything else. And especially on the forefront of the new stuff, I think we see people being more and more invested. Although I think you're right, there are people who are not even aware that they have these rights in this stuff. But once made aware, they become very interested. And it's partly, often they're not that interested in the money, but they are really interested in some kind of control. And of course, I have not met one single person who is not interested in attribution.
Well, Pat, I feel like there's been a tremendous growth with Creative Commons in at least giving people the tools to use copyleft. In fact, James, I wondered whether you used Creative Commons on that site.
That's what I was going to actually comment on, was Creative Commons and even the public domain use of images. Now, if you do a Google search for images, they actually added in there that you can filter now, just public image use, or it's just open for free commercial use. And I've found some amazing images through that, which of course is worrying again as a photographer, that, why do I need to take a picture of the Washington Monument when there's already ones out there that people are using for free?
I'm not disputing that it's there. I'm just saying we have spent the last 10 years interviewing thousands of people in long-form interviews.
Yeah.
And I can't find that people want to give up the possibility of money, the possibility of control, and the limited and somewhat awkward advantage of copyright in terms of lending towards getting them attribution.
I think
Given that we don't have moral rights.
there may be a technical solution that I think a lot of sites should start employing, where there's a new group that popped up. They're kind of trying to be like the Vimeo for Instagram, which is basically like more of a boutique photo sharing site, versus Vimeo versus YouTube. And they're called IM, and I've talked with them. We've had Google Hangouts, chats, things like that. They're looking at a model where they're going to compensate photographers, and you don't default opt in, oh, we're going to use your image for our own commercial purposes when you sign up for our site, but you could select to have your images used for commercial purposes, like Flickr has the Getty licensing. Now, why doesn't every social media site do that and offer compensation that way? In a simple, easy form, and you could opt in, I mean, it makes sense to me.
Based on advertising?
Yeah.
Yeah.
And IAM has an interesting business model where they're actually, they have these weekly photo missions, and they could be sponsored by a company, and that company is going to pay whatever percentage to the top 100 people that were selected for that competition for the week and things like that, if you opt in on their site. So, yeah.
Yeah, I mean, I think the use is growing. I mean, the DMCA aside, for the most part, nobody can stop this. It's impossible to police. Look at what years of MPAA activity on YouTube has gotten us, not very far, because you just find another place to put it back up, unfortunately, for the big rights holders. But I think that most of us, I don't know about the rest of y'all, I'll poll you. When you load a photo, your own personal photo, to the internet, do you think you're going to enforce your copyright? Anybody? Maybe that's because you're law students. So I think that, I think that copyleft is happening, you know,
Well, I'm
whether you
not saying
like
it's
it or
not
not.
happening. I'm just saying it's growing a lot slower
Yeah.
than material that people default think that they actually own.
Well, I mean, you know, since we both work with creatives, I work with them all the time too. Everybody's own copyright is way more important than anybody else's copyright. And that whole case with Patrick Carrow's photograph being taken by a super big, heavy-duty artist just by smearing paint on it. I don't know how you feel about that, James. I don't know. That his lawyers have a really novel idea of fair use, in that if the artist wants to use the other person's work, it is fair use. So, which is all great for the artist and not the other artist.
It's
So-
interesting, though, especially in the area of photography, this is a little outside the bounds of this conversation, but, you know, especially if what we're talking about is sometimes, you know, non-professional amateur photographers taking photos on Instagram, you're going to have like all sorts of, you know, rights of privacy issues too. I mean, if you're taking pictures of your friends and you upload them to a site and you're not paying attention, and that site's going to use it to promote their business, then suddenly your friend's face might appear on an ad for an internet service site, and you know, I don't know how we deal with those complexities.
Well, that's a
as we-
privacy and right of publicity or whatever you want.
Yeah.
Well, that's what I think
Transition.
Google's actually been sued from the Nine Eyes project too, because people were finding their images, and people who weren't even out in the public street, where they obviously don't have the right to privacy, but
Yeah.
they're actually in their house, like looking out the window or something, and they were actually, you know, hey, that's my image. I didn't realize Google was coming past at that point. you know?
Yeah, and I think that's a bigger issue that people aren't aware of. I mean, most people, I think, today are aware of copyright just because it's in the news so much, but borrowing somebody's image without getting their permission, and on Instagram, I mean, during the Ravens parade, I was running around snapping and posting, and suddenly realized that maybe it'd be better if I posted them from the back.
I had a project called Tourist Backs that was all of that, yes, because I've seen so many tourists around DC and just,
Yeah.
oh yeah, I don't need their permission to take their photo if it's just
From
straight.
the back, yeah. So,
Is there a mobile app, is there an app for smartphones for copyleft? Because, you know, somebody says, okay, I'll go on, you know, I'll subscribe to the philosophy, but now make it easy for me. What do they have to do to not have the default mode property?
well, Creative Commons is great because it makes those little symbols, and you can actually put them on your website if you want, or something like that. But I think that a lot of times it might happen by default under the terms of use of the place you're posting it.
So one of the problems with the CC licenses is that you're going to opt for a particular one of the CC licenses, and most people opt for ones that have multiple controls, so some rights reserved. And there's no policing. And most people who use think that this stuff has been posted as either some equivalent of the public domain or under the most expansive Creative Commons license. So it's a confusing situation, but it's made more confusing by the fact that most people seem to want, even under Creative Commons, to reserve significant rights.
If a copyright, if the act of infringement occurs before a work has been registered, and a work can be registered at any time, then the content owner can't get statutory damages, can't get attorney's fees.
Well, I think they have 90 days after. I think
it's
there's,
30 days
or
after
30 days.
publication.
yeah.
But is there in the future, might it be possible to have an automated link? I'm thinking, I'm not a code person. Just like, YouTube has computerized methods of identifying when a copyrighted work is up. Wouldn't it be possible at some point, maybe in the future, for the registration files at the Copyright Office to be, on your smartphone, that you press a button and it would search them to see?
You know,
But
the
there's a
industry,
search engine, which we don't have yet either.
the various industries that are really affected by this, I'd love to hear more from Krista on it, actually, they are in love with the idea of micropayments. But it's been just excruciatingly difficult, not so much from the technical side. The problem is that there are all these layered rights in copyright, and then you put regional on top of that.
Yeah, I mean, I think that would be fantastic. There's just like I think there's no, to me, that's not even reasonably within our line of sight. I mean, I just don't think, as is, you go on the Copyright Office website, and although it's been improved a lot in the last 2 years, I do this all the time, and I think it's difficult to find major works on there. And I'm looking for like a major motion picture that I know is registered, and I find it difficult. So I feel like, talking about that as one possible solution or one way to sort of alleviate these problems is great, but we're so far off, I can't even wrap my head around it, really.
I did actually see, there's a nonprofit, international nonprofit that's managing musicians' rights online. And basically, if you are putting a work on iTunes or you're putting an album out, and you're not represented by a major label, you can go on there and actually register your work. And they're going to expand to photography as well and other forms of media. And I thought that was interesting because it's not like they're competing with the Copyright Office, but they're actually just augmenting it, and actually it's going to be easier to search. They're going to have a better database, and they're a nonprofit, so they're not trying to make money off it or anything either. But they're doing it for the good of the artist's works themselves, and actually, so that made sense to me as a viable model. But is that going to take off? I don't know. But I've been watching that very closely to see what's going to happen.
Interesting.
Yeah.
So this is also another problem with, it's great if you can create a work that incorporates no copyrighted material. It's really great, because then you could actually control it. But a lot of work, and especially a lot of social media work, does not. A lot of it incorporates third-party material. We encountered this when we worked with OpenCourseWare creators, the people who do the online courses that are available to the world. And they use Creative Commons licenses, and they want to give away all their stuff. And it is their heartbreak that professors insist on using copyrighted material to teach instead of all purely original material.
Now, you mean this is like,
Unbelievably enough.
the Khan Institute or Coursera or lynda.com, those types of free education sites, or?
The OpenCourseWare people predated all of those
Oh, okay.
people, and they created stuff like MIT OpenCourseWare.
Oh, okay, yeah.
And some of that material can now be used in MOOCs, but MOOCs have other issues. But this was where I just keep finding everything, including in this open copyright environment, coming back to the question of, okay, in a really restrictive copyright environment, how do we employ fair use fairly? And that's why we've focused on that aspect of it, because we just keep seeing that it's really hard for people to create without coming back to that question of what are the opportunities for me, and also when is going too far.
I mean, I don't know if this would change it any, because if we went back to a registration requirement, then most of the stuff that's copyrightable today would just sort of fall off into the public domain immediately.
It'd be fabulous.
But we have treaty obligations, unfortunately.
Yeah,
And-
plus
and
which,
very
I mean,
few-
which of the stakeholders wants to roll back that particular, the default option among others?
it may just be, it's going to happen de facto, possibly, just because there's so much of what gets created today is high quality, but low, doesn't last for very long, it just goes away.
I'll make one comment and then turn it over to questions from the audience. Our hands are tied in terms of copyright reform because of our international treaty obligations. There's this tremendous interest in global harmonization. I make the point in my class that in 1900, the U.S. was a nobody. Nobody wanted to read an American book. By 1976, we're the dominant cultural power in the world. Everybody watches our TV, watches our movies, listens to our music, and reads a lot of our books. And we got there with this idiosyncratic system under the 1909 Act and its predecessors. So we had the dynamite, absolute, dominant, winning strategy, and so we, without any debate on this issue, adopted the strategy of the losers, which kind of puzzles me, but that's what we did. So now we're open to questions from the audience.